Welcome back, everyone. I see that there are still a few attendees joining the meeting. So if you don't mind, we'll just allow them another minute or two to join the meeting. Yeah, it seems that's everyone that's joined in. So let's carry on. Again, if you don't mind turning your cameras on, I'd really appreciate that. I hope that you had an enjoyable brief lunch and that you have regained your energy for the remainder of the afternoon. There we go. Thanks everyone for that's turned your cameras on. I really appreciate it again. So as I mentioned earlier this morning, that this chapter on the procedure is rather on the boring side, although it is incredibly important, especially considering that South Africa only examines patent applications for formalities. They do not substantively examine applications, and therefore if an application is not formally in order, the application will not be accepted and you will be issued with an official action within which the applicant has a certain amount of time to respond to that official action. So currently, the patent in South Africa is based only on the formal requirements relating to obtaining a granted patent. So these formalities are quite important, and there is case law dealing with specific deadlines relating to acceptance. So we'll touch on all of these important deadlines and also have a look at when an application is filed, how to file it, and the various types of applications that are available to an applicant. So we'll start off with the filing of what we refer to as a complete patent application. And for the purposes of this lecture, I'm going to distinguish between a complete patent application and a national phase application. When I talk about a complete patent application, I'm referring to an application that has been filed either directly in South Africa without any priority claim. So it's filed at the South African Patent Office in the first instance as a patent that will be granted rights, or as an application filed in terms of the Paris Convention, where it does claim priority from a foreign jurisdiction's application within a period of time, 12 months. Then we'll also refer to national phase patent application. A national phase patent application that I referred to is one that has been filed into South Africa after going through the international phase of the PCT, that is the Patent Cooperative Treaty. So those are the two distinctions that I'll be making. Then lastly, there's also a provisional patent application, and we will touch on a provisional application, but at the moment, I'm going to start off with a complete patent application. We'll touch on provisional application in this slide as well, so that you understand the full picture when it comes to filing an application. In practice, what will ordinarily happen is that you will have an inventor that approaches their patent attorney with an invention that they seek to protect. And ordinarily, you will advise that inventor to either file a provisional application or to file a convention application in terms of the Paris Convention, or possibly a PCT application. Now, a provisional patent application is exactly that. It's a provisional application. There are no rights that are granted from a provisional application. What a provisional application allows, though, is for securing your novelty and inventiveness date. So the date at which the courts will assess the novelty and inventiveness of an application. So your provisional application will be the first filed application in respect of that invention. When you file your provisional application, you then have 12 months within which to file a complete patent application. And it's only from your complete patent application that a patent will be granted, and the proprietor of that invention then has enforceable rights, where they can exclude other members of the public from performing certain acts that would otherwise infringe on the patent. It's not necessary to file a provisional application in the first instance. You can file a complete application in the first instance. Then that will be considered your priority filing dates or your priority application. So also, when I refer to a priority application, what I mean by a priority application, it is the first application in respect of that invention that you're seeking to obtain protection for. So it is always the first application in respect of that invention is your priority application. So your priority application can either be a provisional or it can be a complete if it doesn't claim an earlier filed priority application. What is the purpose of filing a provisional application? Is there anyone that wants to give me their understanding of what a provisional application is, why you would file a provisional application, as opposed to filing a complete in the first instance? Yes, Constant.
Isn't it usually when you are still working out like a few of the last issues that it can be linked to the patent, but you would just like to protect the novelty and the inventiveness so long while you are figuring out the last few issues with regards to the patent, just to ensure that the novelty and the inventiveness is secured in the matter?
Yeah, so that's absolutely correct. So you want to secure your dates, as I said, from which novelty and inventiveness is assessed. So you want to file that application as soon as possible to secure that novelty and inventiveness date. And then to make any tweaks that you think are necessary to be able to perform that invention. So you haven't had the opportunity to panel beat that invention per se, or it still needs to undergo further development or testing or trials to be able to perform that invention. So you would file that provisional application for that very reason. There's also another reason, which would be an instance where you need to approach third parties for possible collaboration or funding, whilst there are non-disclosure agreements and such that you can rely on. At the point at which you file that provisional application, you are then no longer bound to maintain the secrecy of that invention. So you are then able to reach out to third parties for funding. It also gives you an opportunity to conduct further market analysis, should you not be ready at the time of filing the application, to determine where you deem it best necessary to seek patent protection. You won't obtain patent rights in a country where that technology is not being utilized. So if you think about inventions that relate to gold mining, I mean, you're only going to seek protection in a country where there is actually gold and that technology is being used in that country. Sorry, I must apologize up front. I can hear my voice is already fading slightly. So I will just stop every now and then to take a sip of water. But if you are having difficulties hearing me, please do let me know. So those are some of the reasons why you would file a provisional application. From that date, you then have a 12-month period within which to file your South African complete application. You could also file a complete application in any of the other Paris member countries. So you can instruct your agent in any of the other Paris member countries to claim priority from the South African application, and that must be done within a 12-month period. You will see that I have listed a specific provision in terms of Section 31(1) of the Act that says that that 12-month Paris Convention deadline is extendable to 15 months. So there is an additional 3-month period within which you can file your complete application, but that is upon request to the registrar to allow that condonation for the further 3 months. But very importantly, this is only applicable in South African instances. So where it is a South African provisional application, so the provisional application was filed in South Africa, and you are then filing a South African complete. So it's only applicable to South Africans, or South African applications rather, not to South Africans. So the provisional must have been filed in South Africa, and the complete is based on the South African priority application. Only in that instance can an applicant rely on this provision where there is a 3-month extension allowed to them upon request to the registrar. So if a provisional application was first filed in America or any other country, then you cannot rely on this extension. Okay, so the prosecution of the application itself in South Africa is relatively straightforward, again, because South Africa is a non-examining jurisdiction at this stage. In terms of the patentability requirements of that invention. So the Patent Office does not conduct a search. They do not check whether that invention meets the novelty or inventiveness or industrially applicable requirements. Only the formalities are examined for the application. Now, the Patents Act provides that an application must be in order for acceptance within 18 months from its filing date. And when I refer to the filing dates, I refer to the complete application's filing date. So within 18 months from that date, all the formal requirements prescribed by the Patents Act need to have been met. Those formal requirements include a specific declaration and power of attorney document, which is known as your Form P3, where the applicant attests to certain declarations that are made on that document. They state who the inventors are on that document. They state that this is the first application, or the priority is the first application in respect of that invention, and a few other declarations that are made on that declaration and power of attorney. There's also a Form P26, which is a declaration that relates to whether the invention relates to or is not related to traditional knowledge, indigenous biological material, or genetic resources. Those two documents are required within 6 months from filing the application. However, you can request the necessary extensions should you not meet those deadlines. Then another document that is most often required, or in all instances where the applicant is not the inventor, so the inventor has assigned their rights to that invention to another party, you have to show how the applicant for this invention is entitled to the invention. So there must be documentary proof that the rights have transferred from the inventor to the applicant for this application. That can be by way of deed of assignment, so there's a contractual arrangement in place between the inventor and the parties. It could also be by way of an employment contract, where the employment contract stipulates that the rights have been assigned to any intellectual property to the employer. Our common law also holds that employee-employer inventions are the property of the employer. There's also case law on that. If you look at the King versus the South African Weather Services case, albeit a copyright case, it does deal with intellectual property, and those principles are also applicable to patents. There might be some additional requirements as well that are outstanding relating to that specification, to that application, that needs to be considered and addressed. And as I said, that needs to be dealt with within 18 months. If it is not dealt with in that 18-month period, the Patent Office will deem that application to have been abandoned. If for whatever reason the applicant is unable to comply with this deadline, it is possible to request extensions for this acceptance deadline. By way of right, the applicant is entitled to a 3-month extension. So if they lodge their request for an additional 3 months, the Patent Office has to allow that request. Any subsequent request beyond the additional 3 months, so anything above 21 months from the filing date, in those instances, the applicant has to show good cause as to why they're requesting that extension. So in the request that they lodge to the registrar at the Patent Office, they will stipulate reasons as to why they are seeking a further extension for that acceptance deadline. And then the registrar will apply their mind to determine whether that extension is permissible or not, and then allow it or refuse the request. Okay, so as we said, that once the application is then accepted, which is evidence of the Patent Office's endorsement of the application being in order, and that it may then proceed to grant. So it is basically the Patent Office's stamp of approval that everything relating to that application in terms of its formalities are in compliance with our legislation, that the patent application may then proceed to grant. Importantly, once the acceptance notice is issued by the Patent Office, the notice of the acceptance needs to be advertised in the Patent Journal within a 3-month period. So see publication of acceptance. Once that acceptance is published, that is deemed to be the date of grant. So the applicant is required to arrange for publication of the acceptance of the application, along with an abstract of the invention and additional bibliographic details, such as who the applicant is, what are the priority details, the filing dates, and the list of the inventors. That is all published in the Patent Journal. And as I said, it has to be published within 3 months from the date of acceptance. If the applicant misses this deadline, then the application has lapsed. Okay, so as you can see, a very important deadline, because this is at the end of the prosecution. The applicant would have already expended a lot of money, not just in filing the application, but in the research and development that took place to get to the stage where they are able to protect their intellectual property. And if it comes to the last step in securing those rights, if that step is missed, then the rights are lost. This is often due to an administrative oversight, poor scheduling by the applicant, or poor scheduling by the applicant's agents, where they haven't diarized these dates correctly, and it is then missed. Those rights into the application have then been lost. So quite a harsh consequence. So then once it's published, as I said, you'll obtain your granted patent, and you will be issued with the Letters Patent Certificate. You'll have 20 years within which to monopolize this invention, and that is calculated from the filing date of the complete application. So the rights are enforceable from the filing date of the complete application. So even whilst the application was pending to grant, if anyone infringed on those rights during the pendency of the application, and there's no prescription in play, then you are still able to enforce those patent rights. Okay, so you have 20 years then from this filing date. This is following the scenario where it is a South African provisional application and a South African complete, because I am referring to this additional 3-month extension over there within which to file the complete. But the same would follow a Paris Convention application where we are claiming priority from a foreign filed provisional application and it enters into South Africa. That period is not extendable as it's noted there. You'll file your complete application and then it undergoes the examination. Okay. Any questions on this timeline that I've set out here?
Hi, Marco. Could you please just explain what that 18-month time period refers to?
Because that's this period, yeah. So from when you file your application, from this filing date, there's an onus on the applicant to ensure that they comply with all the formal requirements relating to that application. So there's certain documents that need to be submitted in support of this application. That's your Form P3, P26, and then proof of the assignment of the invention if the applicant is not the inventor. So the inventor has transferred their ownership in the invention to a third party. There are other documents, depending on what the technology relates to, where there may be certain requirements that need to be complied with, but those are 3 of the important documents that would be required to ensure that an application is in order for acceptance. So if you do not comply with those formal requirements within this time period, so if you haven't provided the patent office with proof that the rights have been assigned from the inventor to the applicant, as an example, within this 18-month period, then the patent office deems that application has lapsed and nothing further will be done on that application. If at the time the patent office examines the application, which is usually before that 18-month period, they'll issue you with an official action. They can do it afterwards, as or after this 18 months, but then you will need to seek the necessary extensions. Whether those extensions are valid in law is questionable, because in most instances, any extension must be requested before that deadline passes. Okay, so you basically have 18 months to ensure that everything relating to that application is in order to allow it to proceed to acceptance. Does that answer your question?
Thanks, Marco. So basically, when you file your complete application, you still obviously have a lot of time to file the forms and to comply. Is that basically what it means?
That's right, yeah. So some of the forms have their own deadlines. So your P3 and P26 form, the declarations, they have to be filed within 6 months of filing the application, but you can request extensions for those as well. So this, yeah, okay. Any additional questions regarding complete applications? Yeah. So as I mentioned, currently South Africa is a non-examining jurisdiction for the patentability requirements. But I'm sure many of you are aware that South Africa is shifting towards substantive examination. There was the IP policy that was published several years back, I think in 2018 or so, where the South African government undertook to introduce substantive search and examination of applications for South African patent applications in terms of best practices globally. And developments have taken place at the Patent Office. The Patent Office has employed examiners, have trained the examiners quite extensively, and these examiners are experts in their technical field. So depending on what that invention relates to, the technology that it relates to will then be assigned to one of those examiners to conduct their examination on that application to see if it meets the patentability requirements. So they are people skilled in the art, being their technical fields of study. So there are several examiners at the Patent Office that have already undergone extensive training. However, the legislation in its current form does require amendment for examination to be introduced. And with my recent meetings with SIPL and our liaison meetings with the CIPC, there are indications that there will be a draft patent bill published in the near future for public comment that will address the issues, or not issues, but to introduce substantive search and examination. What the Patent Office has kindly done to prepare not just the firms, but to prepare the examiners as well, is to undergo practical training where mock examination is taking place on select applications, provided the applicants consent to that examination. So just to permit the examiners additional exposure and experience, they're reaching out to the various patent practices of the law firms to see whether there is an interest in examining some of their applications. And those are then undergoing examination as it would were examination taking place in South Africa. Obviously, those reports that are being produced are non-binding and don't have any legal effect, except for the possibility of disclosure statements that may be required in other jurisdictions. But in most of those countries where there is a disclosure requirement of prior art that is picked up, those applicants are not really opting in for this exercise. But that's just to give you an update as to where South African patent law is moving towards, and it's quite a positive development. Are there any comments on substantive search and examination or the current patent system that anyone may have? Okay, we'll move on then to the next slide, which is the PCT and national phase patent applications. So again, we'll work on the basis that a provisional patent application was filed, and within 12 months of filing that provisional application, you then have to file your PCT application in terms of Article 4 of the Paris Convention. Ordinarily, within 16 months of the priority filing date, the international searching authority that you designated as your searching authority will issue the applicant with an international search report and written opinion. In that search report and written opinion, they will stipulate their findings on whether that invention, in their view, meets the patentability requirements, and they'll provide citations of any prior art that they think is relevant to that invention. Within 18 months from the priority date, so the date over here, this international application is then published online on PatentScope, which is WIPO's website that manages all these international applications, where the specification is filed, the application documents are published, specification is published, the search reports, written opinions are published, and any other documents relating to that application are then accessible online to third parties. So after the written opinion is issued, it is possible for the applicant to request a demand within 22 months from the provisional filing date. Now, what this request for the demand is, if there were any objections that they may have had to the written opinion from the examiner, and they wish to overcome those objections, where they have now amended the claims in such a way to overcome those objections, they can file that amendment and request a further examination of those amended claims. And at that stage, the application will go back to examination and will be again examined by the examiner based on the new amended set of details. And then your international patent preliminary report on patentability will be issued. Where no demand takes place, so no amendments have been filed, no request for further examination has been lodged by the applicant, then your ISR and written opinion is the IPRP. So these two documents are very often. The instance where the two documents are not is where there has been additional examination conducted on claims. Okay, so after this lengthy process, can everyone hear me? Sorry. Okay. Thanks, everyone. Just got a notification to say my speakers aren't working. But as long as you can hear me, that's fine. Okay, so after this entire process has taken place, the applicant is then required to nationalize the international application in the various countries where they seek protection. And they need to do this within 30 or 31 months from the provisional application's filing date. Okay, so it's very important to keep note of when these dates take place. So it's 30 or 31 months within which to nationalize the application from the provisional application filing date. In terms of South African law, we rely on a 31-month deadline. Some countries have a 30-month deadline, other countries have a 31-month deadline. It's all dependent on the national laws of those countries. But for South Africa, it's a 31-month deadline by which to file the national phase patent application. Our Patents Act also permits an extension of that deadline for a further 3 months. Again, this needs to be made on application to the registrar to request this extension to 34 months. So the applicant or the applicant's agent will instruct their patent attorney in South Africa to file the PCT application in South Africa. All that they basically need to do is to provide the agent with the PCT application number or the international application number, and all the documents relating to that application are already accessible for us online. So it's the same documents that are lodged then globally. Applicant enters the national phase, and then once it enters the national phase, it undergoes the usual prosecution in South Africa. For national phase application, those dates are slightly different. As you'll recall from the previous slide, from filing to acceptance, there's an 18-month period within which to ensure the application is in order. But for a national phase application, that 18-month period is decreased to 12 months. Ratse, you have a question?
Yes, Marco, thanks for asking. I think I lost you from publication to.
Sorry, I can't hear you. I'm not sure if it's my speakers or if there's
or maybe it's my mic. Sorry.
Another problem.
Yeah, can you hear me now? Marco? Hello?
Razia, so I think we can hear you. I think it's just Marco that's unable to hear you.
It seems the problem's on my end. I'm just quickly going to disconnect my headset and see if that resolves the problem.
Thanks, guys. Okay, I'm just going to type it in the chat.
Mathieu, would you mind speaking again?
Oh, sorry, I was just busy typing it in the chat. Can you hear me
No,
now?
I can hear you now. Thank you.
I'm not sure if I misunderstood what you were trying to say. With regards to the PCT application moving towards a national, is my understanding correct? You use the content of the PCT application for the national application. Is that correct, or did I
Yes, that's
misunderstand
correct.
you?
No, that's absolutely correct.
But what would happen if the national laws are particular about certain claims being made or specific requirements? How would that play out?
So what would ordinarily happen where examination takes place in the national phase, so in the respective countries, because it undergoes examination, any of those discrepancies or idiosyncrasies between another country's laws and that national law will be raised by the examiner. And then the applicant would have to remedy those in order to obtain grants. But because South Africa doesn't conduct examination, what happens in practice is that we as the patent attorneys take on that role as the examiner. So we will review the South African specification or the international specification that's been filed into South Africa and basically conduct our own examination to consider whether there are any discrepancies or any issues that need to be addressed in order for that specification and claims to be in alignment with South African law, taking into account not just the legislation, but also case law and specific practices in place. So that's basically what happens in South Africa.
Thanks very much.
What also happens very often in South Africa, because South Africa doesn't examine applications substantively, applicants will often wait for examination to take place in another country for that same application. So it's all the same specification, it's the same invention that's being protected in various countries. So if they filed in Europe and South Africa, they'll often wait for examination to take place in Europe to see what objections have been raised in Europe before they allow the South African application to proceed to grant. So if there is any novelty issue that's picked up during examination in another country, they then have an opportunity before grant to introduce any amendments into South Africa to ensure that the patent is in a valid form. And that's one of the declarations that is made on the Form P3, is that at the time the South African patent proceeds to grant, the applicant is not aware of any invalidity in the patent. So if there's a situation where there is an invalidity found in another country and the applicant does nothing about it in South Africa, then the patent can be revoked on the basis that there was a false declaration made. So that declaration is very important to South Africa. And yeah, I mean, people that or applicants that are very serious about obtaining their patents will often delay the acceptance of the application. So if I go back to the previous slides. So at this stage, they will often delay this deadline. They'll make multiple requests until examination has taken place elsewhere, and then allow the South African application to proceed to grant.
So that's what you would call an extension?
Yeah.
Okay. All right. Thanks very much for sharing that.
Just another important to note that you will see came in at the end here, that's hopped into the slide, is that the national phase filing date in South Africa is considered to be the PCT filing date. So even though the application is filed in South Africa 31 months or maybe a bit sooner from the provisional filing date, this international filing date is considered the filing date in South Africa. So the monopoly rights for a national phase application are then calculated from the international phase filing date. So your monopoly is from the PCT international filing date and not from the national phase filing date. So your rights come into effect from this date and not the later filing date. Are there any questions regarding national phase applications?
Sorry, Marco, I just wanted to find out. So let's say, for example, you file a PCT in America. Do you then, if you want to link it to like the different conventions, so for example, either the European Patent Office or the group patent offices in Africa, do you then file it with those different offices as well, and then it gets granted automatically, and then they implement the national phases, or would you need to do it separately for each of those countries?
No, so those various territories, such as the EPO, ARIPO, and UAPI, they are considered basically convention countries. I'm not too sure about UAPI, to be honest with you, but ARIPO, for instance, does accept a national phase application. So you can file a national phase application of the PCT with ARIPO. And when you're filing that ARIPO application, you will designate where that application needs to be nationalized within ARIPO itself. And the same then applies for the EPO. So you can file your PCT application. You can then file a national phase application with the EPO and also designate where the rights need to be granted.
Okay, perfect. Thanks.
Pleasure. Okay, so usually during the exam, there are some questions regarding these timelines. I'll give you a scenario of various filing dates relating to an application. I'll specify what type of application it is, and then ask you some questions as to when the application should have been nationalized. What is the absolute deadline by which an application must be published for acceptance? And a few others like that, also touching on renewals, which we'll have a look at later on as we move forward. Okay, then if we move on to the form of the application relating to provisionals and complete applications, this is probably the most boring part of the next 2 days workshops. Section 31 says that an application for patent shall be made in the prescribed manner and on payment of the prescribed fee, and shall be accompanied by a provisional specification or by a complete specification. Now, the difference between a provisional specification and a complete specification is that the provisional specification does not need to be accompanied by a set of claims, whereas the complete specification does need to include that set of claims in order for the public and the courts to assess what the scope of the protection is and what monopoly the patentee is entitled to. But both do need to fairly describe the invention. Then if you look at Regulation 22, an important regulation stipulating what documents are required in support of that application. It says that the application for provisional and complete must be made on Form P1. It must be accompanied by Form P2, which ultimately is the register page. So the record sheet that is available to the public that includes details of who the applicant is, who the inventors are, priority details, the title of the invention, who the address for service is. It also needs to be accompanied with the declaration and power of attorney Form P3, proof of the applicant's right to the invention, if the applicant differs from the inventor, then obviously your provisional specification on a cover page form P6, or a complete specification if it is a complete application on form P7. Then if there are any drawings that are required to exemplify the invention, to submit those, as well as form P8, which is accompanied by an abstract, and if necessary, an abstract drawing that again exemplifies the invention. The reason for having the abstract and the publication or abstract drawing is so that when a search is conducted on the public records relating to a specific invention, whoever is searching those records are able to identify an invention and whether there is an invention that is similar or the same as one that they are seeking to protect in South Africa. Then there was an amendment to the Patents Act that introduced the introduction of a further declaration, which is the statement relating to whether the invention for which protection is sought is based on or derived from indigenous biological resources, genetic resources, or traditional knowledge or use. I mean, if you think of South Africa, our biodiversity, the various biomes that we have in South Africa, the rich abundance of flora, medicinal properties, phytomedicine in South Africa. This is a very important declaration in relating to South Africa and any inventions that are sought in South Africa, not just in terms of biological material, but also the genetic resources relating to certain materials or biological beings or organisms, and then also the vast amount of traditional knowledge that we have in South Africa. One of the grounds on which the patent can be revoked is if a false declaration is made. So if the invention does relate to South African biological resource and those requirements have not been complied with, and a false declaration is made stating that the invention is not related to an indigenous biological resource, then the patent can be revoked on that basis. An interesting case was it was a situation that arose several years back where the CSIR extracted a compound from the Hoodia plant that was used as an appetite suppressant. So obviously, there's a large market for diet pills, and they probably benefited quite immensely from the sale of that compound that was extracted from the Hoodia plant. But they had discovered the properties of this compound from the traditional knowledge of the Khoisan, who during times of famine would chew on the Hoodia plant, and that would be used as an appetite suppressant so they didn't have these immense hunger pains. And that is a very good example of where, traditional knowledge was used unbeknownst to that community and without their benefit. And one of the reasons as to why a declaration like this is so important, and one of the drivers behind the implementation of this declaration. Okay, Regulation 22(1)(EA just states that declaration is known as Form P26, and every application must accompany it. Even if the application relates to a mechanical invention that is so far removed from a biological resource or genetic resource, it still needs to be accompanied by the Form P26. Then if we look at Section 30, subsection 3B, again relating to this declaration of indigenous biological resources, genetic resources, or traditional knowledge or use, if there is a positive declaration being made, then these provisions come into play, and that is that the registrar shall call upon the applicant to furnish proof as to his or her title or authority to make use of the indigenous biological resource, genetic resource, or of the traditional knowledge or use, if an applicant lodges a statement that acknowledges that the invention for which protection is claimed is based on or derived from an indigenous biological resource. So the registrar has the authority to call upon the applicant to provide proof that they are entitled to utilize that biological or genetic resource or the traditional knowledge or use. Regulation 33B provides what serves as proof to comply with those requirements. So they would have had to obtain a bioprospecting permit in terms of Chapter 7 of NEMBA, which is the National Energy Management Biodiversity Act, or there must be proof that prior consent was obtained. Again, in terms of NEMBA, there must be a material transfer agreement in place, which may serve as proof of the applicant's entitlement to use the material. There must also be proof of a benefit sharing agreement in place. So in the example where the Khoisan had traditional knowledge, there should have been a benefit sharing agreement in place for that community to benefit from the use of their traditional knowledge for the extraction of that compound from the Hoodia plant. Or otherwise, there may be proof of the co-ownership of the invention. So where that community, I do not know how that would actually happen practically, where community would be listed as a co-owner to that invention and then share off the profits of that invention. Practically, I don't see how that would happen unless there is a trust perhaps set up and that trust is an applicant, or then any other proof to the satisfaction of the registrar. Then, as we now know, Regulation 23 provides that there must be an assignment or other proof to the satisfaction of the registrar of the applicant's right to claim priority. So this is not an assignment of invention. So this would be the instance where a priority application, let's say, for instance, was filed in China, was filed by applicant A, but in South Africa, it is a different applicant that is filing an application for patent. You need to show how the South African applicant obtained the rights and is able to claim priority from the Chinese application. So there must be an assignment of the priority rights. So you need to distinguish between the rights in and to an invention and the rights in and to an application. Those are separate rights and they are owned by different people, often owned by the same people, in most instances by the same people. But there may be a situation where an application for the invention was filed by company A, but their South African subsidiary, as an example, is filing the application in South Africa. You need to show that the South African subsidiary is entitled to claim priority from the first filed application. So there you need to provide proof to the satisfaction of the registrar of the assignment of priority rights. Regulation 24 says that if you're filing a complete patent application that claims priority from a provisional application, you need to file a copy of the provisional specification with the application if it is a South African complete that claims a South African priority. Where it is a South African application that claims priority from another country, you need to file a certified copy of that priority application in terms of Regulation 25. And if that priority application that was filed in China is used in South Africa, you need to have a certified and verified translation into one of the official languages of South Africa. So you need to have a certified and verified translation. So that is where a translator attests to the accuracy of the translation of that document. In section 32, subsection 2 states that every application shall contain an address for service in South Africa. This is set out on the Form P3. And as you know, every application is accompanied by the Form P3. Okay, section 35, you don't need to worry about that. Section 36, so in order to obtain a filing date, these are the minimum requirements that an applicant must comply with. You need to pay the official fee. For a complete application, it's 590 Rand for the patent application, which is dirt cheap compared to other countries. The application needs to be signed by either the applicant or their agent. Then a copy of the specification in one of the official languages. If it's not in one of the official languages, then you have 14 days within which to lodge the specification. Also, any drawings need to be filed if there are to be any drawings. If the specification that is filed is not in one of the official languages in South Africa, then the applicant has 3 months within which to file the translation of the specification for complete application. But if it's a national phase application, the applicant has 6 months within which to file the translation. Provision is also made for in terms of section 37, where the applicant can amend the priority details of an application. So then when we're looking at national phase application, section 43(1)(e) states that before the expiration of the applicable period, so that is a 31-month deadline, again, remembering that there is a 3-month extension available to the applicant, they need to pay the official fee. And again, if the application is not in English, they need to lodge the translation. And as I said, that must be filed within more than 6 months. So the application form for a provisional application, a complete application, is Form P1. For national phase application, it is Form P25 is the application form. As I said, very, very riveting information. So just give me one moment. Are there any questions? Okay, it seems you're all fine. Okay, if we then move on to section 31, section 31 deals with when and where you can claim priority from. So section 31A says that you can claim priority from a prior application accompanied by a provisional specification. So if it is a provisional application, you are entitled to claim priority from that application. Otherwise, you can also claim priority from a complete specification, so a complete patent application, where there was no prior priority claim in that application. So if a complete application was filed in the first instance, you can still claim priority from that application as well. And that might happen in an instance where you filed the complete patent application and you have made further developments to that invention and you now wish to protect those developments as well, then you can claim priority from that first filed application and introduce those new that new matter into the further filed complete while still benefiting from the priority date for everything else that was already disclosed. Then section 33(1)(c) states that an application, you can claim priority from an application in a convention country, provided that in claiming priority, the prior application was not lodged earlier than 1 year ago, so that's just a 12-month deadline. The application in the convention country was lodged not earlier than 1 year before the convention application and was the first application in a convention country in respect of the relevant invention. and the applicant in the application claiming priority is a priority of the prior application or has acquired the rights to claim priority from the priority application into South Africa. So again, that is where the Patent Office will require proof of an assignment of priority rights if the applicants between the priority application and the South African application differ. It's so very important to note that the application from which priority is claimed must be the first application for the subject matter in that country. If there is an earlier filed application relating to that invention, that prior application must have first been withdrawn, abandoned, refused without going open to public inspection. Otherwise, you will have lost your novelty to that invention. There must be no priority on that first application, and there must be no further rights outstanding where there is still the possibility of entering those applications into the various countries. Having a look at the statement major that the application from which priority is claimed must be the first application for the subject matter in that country. It often happens, especially from the United States, where they will file an application in America. They will then make adjustments to the specification. They will either file a continuation application, which is analogous to our divisional application, or they will add new subject matter to an application. And they will file an additional application, but claim priority from that first application. Then they will file a complete application. They'll even file a PCT application and then eventually nationalize in South Africa. By the time it reaches the South African stage, there's no valid, or they'll claim priority from one of the later filed applications that was later on filed in the US and have what seems to be a valid priority claim in South Africa. But when you take a closer look at the application from America, you'll see that it actually has prior priority claims to it, which would render the South African case invalid in terms of its priority claim. And there is case law on this, which is commonly known as the Benz case, where the priority claim was invalid because the application from which it was claiming priority from was not the first application in respect of that invention. There were earlier filed applications. So number one, you're sitting with a priority issue there, a possible novelty issue, and then also a false declaration on the Form P3 where you're stating that the priority application is the first application in respect of that invention. And the patent was revoked on the basis that there was a false declaration made in the Form P3 specifically relating to that incorrect priority claim. So very important to check these US applications that enter South Africa, that they do not have a long family history of applications. And if there is a long history, to make sure that whatever's being filed in South Africa, that there is new subject matter included in the South African application, or in the application rather, from which we are claiming priority for from the South African application. Otherwise, you're going to run into that situation where there's a false declaration made in terms of the priority claim. Okay, so if we then move on to Section 32, Section 32 stipulates what the contents of the specification are. So it says every specification shall indicate whether it is a provisional or a complete specification. So that is either done on Form P6 or P7, where it's a national phase application, that requirement is not applicable. Then a provisional specification must fairly describe the invention, whereas a complete specification must also include an abstract. It must sufficiently describe, ascertain, and where necessary, illustrate or exemplify the invention and the manner in which it is to be performed in order to enable the invention to be performed by a person skilled in the art of the invention. And you'll recall that I did mention this specific provision earlier this morning, and that it is a ground for the revocation of the patent if a person is not able to perform the invention based on the description and the contents of the specification itself. So it has to be an enabling disclosure in order to allow a person skilled in that art to perform the invention. And then the complete specification also needs to end with the claim or claims defining the invention for which protection is claimed. What are the requirements for the claims? There's no specific requirement in terms of the claim structure. In terms of the Patents Act, we do know that the Elon transdermal case has provided the claim structure that must be used for first and second medical use of a known compound or of a compound. So for the first medical use of a compound, it must follow the claim structure of the for use type claim. And then if it is a second medical use of a known compound, it needs to follow the Swiss type format of the claim structure. Apart from that, our law doesn't provide for any additional requirements regarding the claim structure. But the Patents Act does say that the claim shall relate to a single invention. It shall be clear and shall be fairly based on matter disclosed in the specification. So there must be fair basis. So whatever you are claiming in the claims, there has to be a disclosure of that itself in the specification, in the description of the specification itself. And then also, we now know the provisions relating to microorganisms, that there should be a disclosure of the accession number for that microbiological deposit. Okay, you can read through this. We've covered all of the details relating to the priority date, so please do just read through that, but it's a rehash of what I have previously already mentioned. Then section 38 also provides for the conversion of a complete patent application into a provisional application, and that is just to allow an applicant additional time should they require more time before the patent proceeds to grant to whatever reasons. It eludes me what reasons an applicant would have to do this, but possibly to obtain a later filing date. But I don't know why they would want to obtain a later filing date, to be honest with you, unless they're wishing to perhaps secure more funding should they wish to enter the marketplace in other countries and then to claim priority from the converted filing date, but it's unbeknownst to me. Or if they just wish to maintain the secrecy of that invention for a little bit longer, they can then convert it from a complete application to a provisional application. However, the requirement is that it has to be within 12 months of the filing date of the application. So you can only convert a complete application into a provisional application within 12 months of that filing date. So if we have a look at the wording of section 38, it says the registrar on request by the applicant at any time before the acceptance of the specification. So it should not have proceeded to acceptance yet, but not later than 12 months from the date on which the application was lodged at the patent office may be converted to a provisional application. There's also the possibility to post-date an application. Again, this might be in an instance where the applicant requires additional time before completing their applications in other countries. However, whether they'll have a priority, a valid claim in those countries where they've post-dated it is yet to be determined. But the Act provides that before the acceptance of a complete specification, the registrar may, on request by the applicant, post-date that application. So you're moving the filing date forward to such dates as may be specified on that request. So you can request the registrar to move that filing date forward. However, it cannot be post-dated to a date later than 6 months from the date on which it was actually lodged. So you have to do it within 6 months of the filing date. And then if that application claims priority from an earlier filed application, you can't post-date it to a point where you no longer have a valid priority claim. So it must still be within the 12-month window within which to validly claim priority. So just to say that again, an application claiming priority may not be post-dated to a date later than the last date on which the application could have been lodged. So you still need to ensure that there is a valid priority claim. Are there any questions? Okay. Okay, so if we have a look at Section 34 and Regulation 40 regarding a provisional application, again, it just states that the Patent Office is only required to examine the application for compliance with its legibility and that it is capable of being reproduced, and also for examination that it complies with the requirements of the Acts and may then accept it. The further steps, a lot of this we have touched on already, and you can work through that. Again, if you look at Section 34, it states that the registrar shall examine every application for patent and every complete specification accompanying such application. If it complies with the requirements of this Act, he shall accept it. Some people argue that Section 34 does make provision for the registrar to substantively examine the application because it doesn't expressly provide for formal examination only. It just says the registrar shall examine every application for compliance or with the requirements of this Act. So it could be inferred that novelty, inventiveness, and industrial applicability fall under this ambit. However, there are no other provisions, there's no regulation in place as to how that examination should be conducted, what are the procedures relating to substantive examination, you know, the various timelines applicable to it, any opposition that might be available to an applicant, opposition to grant. No such provisions are provided for in the Act or the regulations. Okay, for the rest of that, you can have a look through that slide on the notes on procedure. Again, just a rehash of some of the regulations that are not so vital for you to have knowledge of at this stage. Okay, you'll recall when we looked at that initial timeline and when we had the question based on an application proceeding to or being in order for acceptance within 18 months from the filing date or 12 months for national phase application. So if it's not accepted with or not in order for acceptance within that 18-month period, as I said, the Patent Office will consider that application as lapsed or abandoned by the applicant unless an appeal is filed or if there was no undue delay on behalf of the applicant's part. So if the Patent Office took longer to examine that application, to issue the acceptance notice, in that instance, the application is not deemed to be abandoned because it's due to no fault of the applicant or omission on part of the applicant. And as we also know, that deadline can be extended for the first 3 months as of right, and then for any further period, good cause must be shown. Regulation 44 stipulates that as soon as the registrar is satisfied that the application complies with the Act, and unless there has been any request to delay the acceptance, the registrar may then issue the acceptance notice, so giving notice of the acceptance of the application. Once the application is accepted, the registrar gives notice in terms of Section 42 of the acceptance. The notice contains the date of acceptance and then a statement that on publication, the patent is deemed to have been granted. In terms of Regulation 46, acceptance must be advertised within 3 months of the date of acceptance. That is extendable, and reasons need to be provided as to why you are seeking such a request. If acceptance is not published, as you already know, the application shall lapse. Here's just an illustration of the acceptance notice. Sorry, it is an outdated version. The acceptance notices for patent applications are being issued electronically now, so it does look slightly different, but the contents is by and far the same. So this is just stipulating that the application has been accepted by the Patent Office. Okay, so there was case law that dealt specifically with the period within which to publish acceptance. So that is the 3-month period from the acceptance notice's date of issuance and the date of grant. In terms of the Act, if it is not published, the application has lapsed. This was the subject of the case in the University of Pretoria versus the Registrar of Patents and others, where the court held what had happened in this case. There was various issues dealing with acceptance, one being the acceptance deadline, where no requests were made and there should have been requests made, but also once acceptance notice had issued, it was published outside of the 3-month deadline by which to publish the request, and no requests for the extension were made prior to that deadline passing. So the court held in the University of Pretoria case that if at the date when acceptance of a patent application is due and there's been no request for an extension of the acceptance period, so this is referring to the 18 or 12-month period, and the patent application is not in order for acceptance, the patent application lapses. So they reaffirmed what the legislation states. There's no possibility of extending the period of acceptance further after the date when the acceptance is due has passed. This is because of the peremptory wording of Section 40. So the request for that extension of the 18-month acceptance deadline or 12-month acceptance deadline must be requested before the expiry of that case having been put in order for acceptance. Otherwise, the application, again, is deemed to have lapsed. Also, the wording of Section 42.3 is peremptory, and that deals with the publication of the acceptance notice in the Patent Journal. Unless acceptance of the application is published within the prescribed period of 3 months, as you now know, the application shall lapse. Interestingly, then the court said that it is not possible for the registrar to extend this period unless an application for the extension has been made by the applicant, good cause has been shown, and the prescribed fees have been paid before the 3 months is up. So very similar to what they held regarding the acceptance deadline of 18 or 12 months, that request must have been made before the expiry of the 3 months. So it is possible to request an extension for publication of acceptance. However, that request must be lodged in terms of University of Pretoria case before the expiry of that 3-month deadline by which it needs to proceed to grant. And again, as I said earlier, good cause must be shown. So you need to provide the registrar with reasons, because the registrar has a discretionary power to either refuse or allow the request. So that was the law as it stood until 2023. Because in 2023, we have the judgments of Mu Mechanicos Unidon versus the Registrar of Patents. So this was not necessarily in terms of the court, a case that I was involved with, but involved with the procedural aspects and administrative aspects of this application. It was a case that I had taken over from another agent in South Africa, and upon reviewing the case, noted that the case was not published in the Patent Journal timeously. So if you have a look at the dates and the set of facts, the applicants for the patent was Mu Mechanicos Unidos, and the Patent Office accepted their application on 30 June 2021. And then it was published in the Patent Journal on 27 October. But if you calculate 3 months from 30 June, it would be July, August, September. So this case's acceptance had to be published in the Patent Journal by 30 September 2021. So as you can see, publication occurred more than 3 months after the acceptance of that application. This was then brought to the applicant's attention when I took over this particular case from the previous agent, stipulating the law as it currently stood in terms of the University of Pretoria case, where, as the law stood at the time, the
We've lost you, Marco.
there we go. I think I'm back now. Can you hear me?
Yes.
Perfect. Thanks, Michelle. So sorry, just to repeat that, in this instance where there was no request to extend this publication date lodged in support of the application, so there was no ground for which this patent was permitted to have been published later than what it should have been. So no good cause was provided. There was no request for the extension of this.
What happened again?
Sorry, it seems the internet is the rest of us are at the moment. But obviously the applicant was not pleased with the advice that we had provided, but it was the advice provided in terms of the law. And they then sought remedy from the agent that actually handled the prosecution. Sorry, Kaylee, I noticed in the chat that you mentioned we don't have slide 68. This is an important slide that I've put in this morning, so I will send an updated version to everyone to ensure that you do have the slide, because it is a very important case, an important outcome from the court of the Commission of Patents. So thanks for bringing that to my attention. I will share this. So they then sought remedy from their initial agent that filed and executed the application to grant in South Africa. They then submitted a request after the 3-month date, requesting that this publication date be extended. But if you recall from the University of Pretoria case, they said that it has to be requested before the 3 months is up. However, the matter was then taken on to, or sorry, before the matter was taken on, after that application was lodged requesting the extension on 3 May, the registrar refused the application. And the registrar's decision was based on the outcome of the University of Pretoria case, where the reasons provided for the refusal by the registrar was that according to the University of Pretoria versus the Registrar of Patents, the peremptory language of section 42.3 and regulation 46 has the following implications. The request for an extension of the period of publication must be made before the expiry of the 3-month period. Good cause must be shown and the prescribed fees paid. So they didn't comply with this requirement, and also the reasons that were provided by the previous agent, in my opinion, were rather weak. It was during the COVID pandemic that I don't think this application was diarised properly. But yeah, that's neither here nor there. In any event, the registrar refused the application, and then the matter was taken onto the Commissioner of to the Court of the Commissioner of Patents to make a final determination. So the registrar was then taken on review. So Mu Mechanicos versus the Registrar of Pretoria, that is where this thing comes into the greater scheme of things. So if we look at what the judgments held in terms of Bonus A, which is the University of Pretoria case, and Mu Mechanicos judgments, late publication of the acceptance of a patent application without any application for extension of the deadline for publication results in the lapsing of the application. So that's fine. Both judgments have found that there must be a request for the extension of the publication date. However, after that lapsing, it is possible to obtain an extension of time for the publication of acceptance at the discretion of the registrar, provided that good cause is shown and the prescribed fee is paid in order to rectify the lapsing of the patent. So the court made the determination that what the University of Pretoria held over here, that the request must be made before the 3 months is up, is incorrect. And they provided the registrar with the discretion in terms of 16.2 of the Patents Act to apply themselves in the either allowing or refusing that request. But ultimately, the court said that it is possible to request that extension after the fact. So I say that the Mu Mechanicos judgment is good in that it provides clarity in cases where the publication of acceptance occurred after the 3 months deadline and an application for the extension of the deadline for publication is subsequently filed. So we now know that you can request this extension after the 3-month deadline, but the registrar still has the discretion to either refuse it or allow it. In this case, the court said that it should have been allowed. But the court did then reiterate that the registrar has discretionary power in terms of 16.2 to grant an extension for publication where it is made after the deadline. Whether the finding is correct, I don't know. Any comments on that? Do you think it's correct, not correct? I personally see a lot of problems with it. For number one, if a third party was to view the registrar in terms of case law, in terms of the Patents Act, the application is considered lapsed. So they may then, in that instance, start exercising rights over that invention. So they may be manufacturing that invention, and they might think that they are doing so legally, where they are not infringing on any patent rights because the application has lapsed. It should not have proceeded to grant. What happens in the instance where that is the scenario where somebody is exercising that invention under the impression that it has lapsed, but after the fact, a request is now filed, as was the case here, to request the extension for the deadline here, and it is then allowed. Is that third party then infringing on the patent? What remedy do they have? Should the patentee decide to pursue an infringement action against them? That's rather problematic for me. Another thing is, what is the purpose of having a deadline when at any point you can just request an extension, even after you've missed that deadline? Any comments? No. Does anyone agree with the judgment? Anyone against the judgment? Okay. No comments. So let's move on then. So the next slide then deals with inspection by the public. And this is, when does an application become open to public inspection? When does it become a public document? When is the disclosure in the specification part of the public domain? And this is dealt with in section 43.1 to section 43, subsection 3. It states that the patent and the application and all documents lodged in support of the application are open to public inspection in the patent office after grant or publication of acceptance in the patent journal. The priority document will be open to public inspection at the same time. So upon grant, if the application with a foreign priority has not proceeded to grant within 18 months of the earliest priority date, it shall be open to the public. So the first bullet point deals with a scenario where it's a South African provisional application that is completed by a South African complete. In that case, the application will only become open to public inspection on the date of grant. That is the only time. So once it proceeds to grant. If it's a convention application that claims priority from a foreign priority application, so South African application that claims priority from a US filed priority application, will become open to public inspection within 18 months from the earliest priority date. Okay, so be aware of the distinction between the two. So the first is where it's a ZA priority and ZA complete. This is where it's a foreign priority and a ZA complete. For a national phase application, because it is an international application that is filed in South Africa, that national phase application would have already been published during the international phase and is therefore already open to public inspection upon publication of the international application. So you'll remember when we looked at the PCT timelines, when the international application is published, which is usually 18 to 22 months after filing the PCT application, it is then published on Patent Scope of WIPO's website, and those documents are then already publicly available. So the South African national phase application in most instances is already open to public inspection by the time it is filed in South Africa. Okay, if we then move on to sealing and grant, section 44 provides that the patent is to be sealed. That is, the letters patent document must be issued, and it must be done as soon as practicable after publication. The sealing is effective as from publication. So even though the patentee will receive their patent certificate or letters patent document several months after grant, it is effective from the publication date in the patent journal. Importantly, section 44 provides that a patentee may not institute infringement proceedings within the first 9 months from grant, unless the Commissioner grants leaves to institute proceedings at any time after grant on good cause shown. So there is a 9-month moratorium within which infringement proceedings can be instituted by the patentee. That can be waived if application is made to the Commissioner of Patents and that there are good grounds for the reason to waive that moratorium. Okay, then this is just an example of what the patent journal looks like and what is published in the patent journal. So we've got the cover page of the patent journal. This one's from May 2017. And then with the details of the patent itself. So when I refer to the publication of acceptance, it's the publication of this information. We've got priority application details, the filing dates, the classification. So what technology does this invention relate to in terms of the International Patent Classification Codes, who the patentee is, Procter & Gamble, the inventors, priority details, title, abstracts, and abstract drawing. Is everyone still good to continue? Do we need a 5-minute break? Hi, Lebo. Okay, we're good to continue. I don't think there's too much left of the procedure section. So we'll finish that off and then end off for today. So if we look at Section 39 provides for the application of a patent of addition. So that is over and above a complete application that we have already filed. Now, a patent of addition can be applied for any new modification to the already filed patent application. So where the applicant has made some modification or there is some improvement to that invention that was disclosed in the already filed application that they now seek to protect as a novel feature to the invention, then they can file a patent of addition. So if we have a look at the wording of Section 39, it says that where a patent for invention has been applied for or granted, so this is very important to note, is that a patent of addition can be applied for at any time, basically. So it's either while the first filed application is pending, or even once it has proceeded to grant, can the patentee or applicant request for the patent of addition to be filed. And the applicant or the patentee applies in the prescribed manner for further patent in respect of any modification, addition to improvements of the invention described or claimed in the complete specification of the main invention. He may be granted a patent of addition. So as I said, you can apply for this either when the application is pending or even if the patent is granted. The life of the patent of addition, however, is not 20 years from the life of the filing of the patent of addition. It is the remainder life of the main invention itself. So if the patent application for the main invention was filed 5 years ago, when filing the patent of addition, you only have 15 years life on that patent of addition. So it's the life of the patent of addition is the remainder of the life of the main patent. However, on request, the registrar may revoke the main patent or the and grant then the patent of addition in respect of those improvements, and it will then be provided with the same date of application as the independent patent, as I mentioned earlier. So if we just read through that, it says, on request, the registrar may revoke the independent patent and grant a patent of addition in respect of the addition, improvement, or modification having the same date of application as the independent patent, so revoked. So even if the independent patent is revoked, the patent of addition will retain the filing date of the main application that was filed. Then where the patent for the main invention is surrendered, revoked, refused, or abandoned, the patent of addition shall, unless otherwise directed, become an independent patent, and the normal term of such independent patent shall not extend beyond the expiry of the patent of the main invention. So a patent of addition will never be able to extend the life of that invention. It will always have the same life as that of the main invention. In terms of renewal fees are ordinarily not paid for patents of addition. So the prescribed renewal fees that would ordinarily have been payable on the main invention, should it have been revoked, will then become payable on the patent of addition. I see we've got a question. Can a different applicant file the patent of addition after the main one has been granted, or will it be considered infringing? No, the application will have to be made by the same proprietor. And you'll also see in the last point on the slide below, the reason for that is also that the main invention and the patent of addition are in one way inseparable, in that they cannot be assigned separately. So you cannot have two different proprietors or two different applicants over both. It has to be the same applicant or patentee that applies for the patent of addition. Importantly then, as one application for a patent of addition shall not be accepted before the main patent is accepted. So the Patent Office will first have to examine the main invention. If it is pending, they'll need to examine that application for the main invention before the patent of addition is accepted. Then it is also not possible for the main invention to be considered not inventive against the additions to or improvements to the invention. So the first filed patent or patent application is not considered novelty destroying. Not novelty, inventive. It doesn't lack inventiveness over the first filed invention. So if you have a look, it says the grant of the patent of addition shall be conclusive evidence that the invention is proper subject matter for such a patent, and shall not be refused, nor shall any patent be liable to be revoked or invalidated on the ground only that the invention claimed in the complete specification of that patent of addition does not involve an inventive step having regard to the main invention. Hi, Lorraine.
Hi. Sorry, I can't remember if you touched on this, but let's say for any reason the renewal fees were not paid in the main patent and that one lapsed. Is the patent of addition still valid?
No, because as soon as the main invention would have lapsed, then automatically the renewals would have become due on the patent of addition. If it is still possible to pay the renewal fees validly, then you can do that on the patent of addition. Does that answer your question?
Yes, thank you.
Yeah. Yeah, so if you look at this first bullet point, yeah, it relates to that section there, that the prescribed renewal fees which would have been payable would then become due. So if the applicant did not renew the main invention, then those renewal fees would have been due on the patent of addition. Okay, so we've now had a look at patents of addition. We'll then move on to divisional applications. And this is provided for in section 37. And as I said earlier, this is analogous to the continuation applications in the United States. But section 37.1 provides that where at any time after an application has been lodged at the patent office and before it is accepted, So important to note that a divisional application can only be filed before the parent application has been accepted. So a divisional application must always be filed before acceptance of the parent application. A fresh application is made in the prescribed manner by the same applicant in respect of part of the matter disclosed in the first mentioned application. The registrar may, on application made to him in the prescribed manner, before the application is accepted, direct that such fresh application be antedated to a date not earlier than the date on which the first mentioned application was so lodged. Patent granted on such fresh application shall not be revoked or invalidated on the ground only that the invention claimed in such fresh application is not new, having regard to the matter disclosed in the first mentioned application. So in terms of the requirements for a claim, you'll recall that a claim can relate to one invention only. And often in drafting of these claims and specifications, they do relate to more than one invention. It happens where there is a disclosure in the specification that, for example, relates to the method of manufacturing a pharmaceutical, and then there's also a claim directed to the pharmaceutical compound itself. So those are two separate inventions. There's a method of manufacture, and then there's also the invention of the compound itself that you're wishing to protect. And all of this is disclosed in one specification. Now, what a divisional application permits is for that specification to be divided out. So where you are granted a patent for the method of manufacture only and one for the compound only. So that is what the purpose of a divisional application is. It is to divide out the invention into the separate inventions. And there are often objections raised in examining jurisdiction where there's a unity of invention objection. And that is where the specification discloses more than one invention, or the applicant is claiming more than one invention. In terms of South African law, although the Act says that the claim must relate to one invention only, there's no remedy against doing that. And you cannot revoke a patent on the basis that it comprises of more than one invention. But it comes down to an argument that there might be a clarity issue as to what the actual invention is, should the courts ever need to make a determination. And so it is safer to file divisional applications. And these are done on a daily basis in South Africa. There are multiple divisional applications filed in South Africa where there is a disclosure of an invention, but various embodiments of that disclosure can be protected as separate patents. So what would happen in practical terms is the same description is filed for the divisional application because the disclosure is the same, but your claims would be directed to a different part of that invention. So if we look at the pharmaceutical example, the description, the background of the invention, all of that will be the same for the parent patent being or parent application being the first filed application that discloses both, and for the divisional application. And you will then file different claims for the divisional application so that you focus on one embodiment that you're wishing to protect. So what you'll do is to ensure that it's properly divided out is that you will amend the parent application to remove the claims that you are now going to include in the divisional application so that you have two separate patents for two separate inventions. So one would then be towards the method of manufacture, and then the other would be for the compound itself. But as you now know, a divisional application has to be filed before the parent application is accepted. And also the other requirement for when filing a divisional application is that it must be antedated. So in the application for the divisional application, you'll submit a request to the registrar to antedate the divisional application to have the same filing date as the parent application, and that then ensures that the divisional application still has valid priority claims, so that you don't run into a scenario where there is no valid priority claim. And then you also, in that way, are not extending the duration of your monopoly. It will still be a 20-year monopoly from the first filed filing date of the parent application. Okay, so their term will run concurrently with one another, and both patents will expire on the same day. Any questions on divisional applications? No, it sounds like everyone's going to get 100% for the exams. I'm very chuffed. Okay, there is some case law on divisional applications, which is this Pharmadynamics versus Bayer case. And these were just some additional requirements relating to divisional applications that the court had set out. And they said that the claims of the divisional application must not be coterminous with the claims of the parent application. And that makes sense. I mean, what is the purpose of filing a divisional application if you're going to have the same claims? Your claims must be directed to different subject matter that you're seeking to protect. However, there can be overlap between those claims, and the divisional's specifications claims can also be wider in scope than that of the parent, provided that the claims are not the same. But as I said, there may be some overlap between the claims themselves. Okay, that brings us into the end of divisional application. Again, you can read through a term of the patent. I think everyone is very familiar with the term of a patent now. We know that it's 20-year duration from the filing date, but remember to make the distinction between the various filing dates of a complete patent application and a national phase application. For complete application, it is 20 years from the complete filing date, so the date that the application is submitted to the South African Patent Office, whereas for national phase application, it is 20 years from the international filing date. So when the PCT international application was filed, the 20-year term runs from that filing date. So important to please make that distinction. Okay, that then brings us to renewal fees, which is towards the last section of these slides. But I am beginning to lose my voice quite severely at the moment, and I am certain that everyone is quite tired at this stage. So I'm happy to pause here for today and then to pick up on renewal fees again from tomorrow if everyone's happy with that. Are there any questions on the subject matter that we've covered so far? Okay, if not, and I hope I haven't given you any nightmares for tonight and that everyone does return tomorrow and that I haven't scared you off, please do have an enjoyable afternoon, rest well, so that you're fresh for tomorrow's next session. Generally, the second day does move a little bit quicker than the first day. So I do expect that we'll finish off a little bit earlier than what we did today, tomorrow when we resume. But thanks everyone. I appreciate your attendance and look forward to seeing you tomorrow. As I said, if you do ponder on any questions or require some clarification on anything, we can pick up tomorrow morning then. Okay, take care.
Okay.
Thank you, Marco.